I got the bailiff who had clamped the car, I got the bailiff to state 3 times in the presence of the cops that he intended to take the vehicle. I had a document in my hand that said, "You're no longer the owner of this vehicle." And I had a woman standing here with a document that says, "You are the owner of this vehicle." But he 3 times said he intended to take the vehicle. So I turned around to the sergeant and I said, "I now want to report a breach of the peace involving the crime of theft. Will you accept this report of a crime?" Now she knew what was coming, nothing she could do about it, and she started shaking. So I looked round, got some friends standing over, lawful rebels, ex-army, called them over. I said, "I need a witness." So I turned around to the sergeant and I said, "Okay, one last chance. I want to report a breach of the peace involving the crime of theft. Will you accept this report of a crime?" I gave her 3 or 4 seconds and she was really shaken by then. And I used a very, very powerful word. I leaned in and I said, "Are you refusing to accept this report of a crime?" Very powerful, that refusing. At which point, you know, she was just fucking, she was like that. Her clothes were coming off her, she was shaking so much. And then at that moment I heard the bailiff behind me saying, "Okay, I'm taking the clamp off and leaving." And I was so surprised, I turned around and I said, "Let me get this straight, you're going to take the clamp off and leave?" And he said, "Yes." I said, "You're not getting any money?" He said, "No." I said, "You're not going to have the car towed away?" He said, "No." And I went, "Okay, goodbye." He drove off. I turned around to the sergeant and I said, "I'm glad nothing untoward happened." She was still fucking shaking. And she said, "So am I." If I'd been a bit more awake, that bailiff would have gone to jail. Absolutely guaranteed he'd have gone to jail. I would have left him no choice at all. If necessary, I would have arrested the bailiff. And if the cops had interfered, I would have arrested them. You have that power. Policemen have no more power than you. In some ways they have less power because they're controlled by rules and regulations that you aren't. If the police don't do their job, force them. You tell them, police discipline codes, perverting the course of justice, defeating the ends of justice, negligence, failure of duty. I'll give you a copy of my lien because contained in my lien as part of the proofs of the allegations are these laws, these appeal court decisions and so on and so forth, what the Lord Justices have said about these various matters. You must examine the documents, you must arrest them. All sorts of stuff about hitting the bailiff on the head with a bottle of milk, giving him a good slap. It's not a crime. It's not a crime. And you should get to know about trespass. Trespass is not about possession. It's not about ownership, it's about possession. If it's about ownership, you couldn't stop people walking in and out of your council flat. So it's about possession. You have the right to say no. And you know about removing the implied right of access. Mm-hmm. Well, I've got the law regarding that, and you can have a bit of it with this stuff. Once you've removed that implied right of access, if they remain, cops, bailiffs, it doesn't matter, they're no longer in the execution of the duty. They're acting as a mere private individual. They have no police powers of arrest, enforcement, or anything. And they become liable on a claim for damages. That's the law. Now, there's a thing in law called injuria sine damnis. That's injury without damage. The guy stood in your doorway and wouldn't move. He's done you an injury. There's no damage as such. But it's recognised in law and they are liable on a claim for damages. And there very often is a case where the police are equally liable for a claim along with the authority who engaged the bailiff. Now there's some argument about whether or not you can actually sue a bailiff or whether you can actually sue a cop. Because if they're acting in the execution of their duty, you won't get a claim. They're within the law. The moment you have a claim, it means they've acted outside of the execution of their duty. Therefore, at that material time, they were not a bailiff, they were not a councillor, they were not a constable, they were just a private individual. Now what that means is that they're cut off from their insurance bond. The bailiff's insurance, the police insurance, the council insurance. They're cut off from that. They're operating on their own recognizance. They can't turn around to the council and get money for defence. They can't engage council lawyers or police federation lawyers. They're cut off from their bond.
It all comes back round to that word liability. Magic.
How does removal of implied right access affect if they've got a stamp court order?
What, the EX
Doesn't matter.
Can it still remove it?
Yeah.
Even if they're acting on the decision of the court?
Yeah.
Yeah.
Even with the High Court guys who've got a bit more power,
Yeah.
they can't, they don't say you're in trespass, you have to get off. They've got to go and stand outside the gate and talk to you from there. They have to. Private property. Private property rights are incredibly powerful in our law. Right. There's something here that you won't get from Simon Spaniard or Guy Taylor or anybody like that. Because when I first started putting this stuff out, I put this out. No, that's not good. But not many people were bothering with it, so I stopped putting it out. A little while ago I resurrected it.
If you click on the blank sheet and hit delete, it should get rid of this blank page. Or backspace rather, not delete.
Right, what this is a notice of distress of public indemnity insurance. Now what I used to say to people was, print something like this out. Leave nice big space to write in. And if you're up in court, for example, and the judge is messing with you, and you got your Mackenzie friend, or just someone sitting with you, you're going to have this with a pen. And the only thing they're interested in is what's the judge saying and doing. If the judge is scuttling your case, if he's practising law from a bench, if he's doing anything outside of his duty to fuck with you, then your mate sits there and writes it down. And at the end of it, pass it to you, you sign it, and you give it to the judge. I don't know what the hell's going on with this. Let's try again. That's better. So, once again, parties, allegations. You're not going to put proof of allegations here. You're just going to write down the allegations. That you were negligent, you committed fraud. We had a judge who took a decision from the Lord Chief. He was the President of the Supreme Court, Lord Phillips at the time. Now it's Lord Neuberger. At the time it was Lord Phillips. And we had a thing on mortgages from Lord Phillips. This is a fucking Supreme Court decision. That the mortgage deed is not a contract, and it's not evidence of a contract. A contract must be an entirely separate piece of paper with two wet ink signatures. So we had that as a killer case to destroy the mortgages. And we were up in Bristol in the County Court of Registry with Michael Berenice here and a couple of other people. And we had a killer case, and right at the last moment, we put this in. And the judge had been suave, articulate, intelligent, very nicely spoken, as they are. And she read through this. And then she read through it again. And she put it down. And before she could speak, one of the guys, Paul, picked up a copy and he said, hang on a minute, and he read it through to her. So she's had it 3 times. Now she's just a district judge in a county court of registry. She's nowhere near fucking president of the Supreme Court. She turned from intelligent, articulate into a stumbling, mumbling, shaking, well, you know. And in the end she said, well, in my opinion, you're in a contract. I went, whoa, you can't do that. She just practiced law from the bench. She just made law from the bench. where she said, in my opinion. She's taken a Supreme Court decision and substituted her own opinion for it. She can't do that. So that's that kind of point where this comes out immediately and you fill in the blank here. This is what you did. Now the whole purpose of this notice of distress is to command specific performance. In other words, do your fucking job. You're not doing your job here. Do your job. So this is to get specific performance. Do your job. Because you're not doing it right now, you're screwing us.
So when, at the Melanie Shaw trial, when Judge Pert summed up to the jury and told them that Operation Daybreak was a figment of Melanie Shaw's imagination, delusions,
Yeah.
could that have gone on there?
Does Operation Daybreak exist?
Yes.
Yes, yeah.
Right, okay, so...
And the judge knew that it had been reported on TV before then, hadn't it?
Lied in office.
Yeah. Because that's probably what's, even though...
Was she in a court of record? Criminal court?
Yeah, she was in Crown Court.
Right,
Nottingham Crown Court.
Transfer.
okay. Right, well the remedy there is that you put in an appeal. An appeal is based on the summing up. At least part of it would be based on that the judge gave false evidence or false information to the jury, which may or may not have been
We've
true.
been saying that, haven't we? We can't get to do now.
The proof would be the
Yeah.
transcripts.
We need to get
You can
power of
Yeah.
attorney from her and then proceed.
In a case like that, something like this could have been handy.
No, absolutely.
Because what's happening here is that you're trying to compel specific performance, just do your job. And the value of that, the surety for that, is her insurance. So when the judge reads that, do your job, or I'm coming for your insurance bond, she knows, the judge knows, he knows, that the next thing coming in is going to be a commercial lien for the value of the bond. Now, 4 or 5 years ago, I was putting this stuff out, trying to persuade the freemen to start attacking the officials, because this is how we control them.
Yeah.
This is how we can get them out of that job. It's how we can keep them in the job and say, you've got to do what we tell you, mate.
We do a couple and they all start towing the line.
I said before, when you hunt one, they all run. Hunt one sheep, the whole fucking flock runs. So the next thing that's going to come in after this is a commercial lien, and the judge will know that. Now, about 4 or 5 years ago, I was writing out about this stuff, and I was up in a court up in Telford with a couple of the guys, and on the way back down, I did a write-up for the court case, and then I added a little bit more about the judge's bond, because I'd found more information. According to the Ministry of Justice, judges were self-bonded. They had no insurance like we have it, where somebody else holds a policy. They were just saying, well, I'll bond myself.
My word is my bond.
Yeah.
Yeah.
But in insurance law, limited liability, self-bonding is no bonding. It's insurance fraud. So all the judges were sitting in court in fraud. What they're saying is, I'll pay out of my own pocket. But what are they doing with the money in the pocket? They're spending it. Living allowances, cars, rents, mortgages, whatever they're spending the money on. They're actually dipping into the insurance pool that's going to pay for any torts that they worked. So I updated that little bit. Then I found out later on that they're actually not even self-bonded, because they're just operating on a promise to pay. They have no insurance cover.
So you can bankrupt a judge using a commercial lien.
Yes, that comes out of their own pockets.
Ka-ching.
It's another one of the many things that somebody needs to take up, you know, about this business, about officials acting without a proper indemnity fund.
Did that clerk do that last week? We was at the new case of Melanie's last week, and the judge, I think it was a QC actually, he wanted to back up in court sometime in May, but then the clerk, he asked the clerk what dates was available, and the clerk actually said, I'd like to get a backup in front of Judge Pert, who is the original judge that said
That's
all
because
that.
they're trying to
Now,
contain
is the clerk
liability.
allowed to actually say that?
Clerk talking to a magistrate.
To the I think it was a QC one in the Crown Court, advising the QC as to, the judge had asked when there was an available date for Melanie to come up for trial.
Right, do you know a
And the
website
clerk.
called What Do They Know?
Well, I'll write it down. Yeah.
Um,
It was only advising, but
right, well,
He said-
several years ago, I was saying to people that when you're going up into court, the clerk of the court is the guy you've got to tangle with.
yes.
Forget the magistrate and
Yeah.
the judge, deal with the clerk
Yeah.
of the court. So what I did was, if you go onto that website, you just Google, what do they know?
Yeah.
And it's a Freedom of Information website,
Yes, yeah.
right, that's public. And you just register, you log in, and there's an alphabet, you go through the alphabet, you go to M, click on it, and you go down, Ministry of Justice. And then you do a Freedom of Information to them that everybody on the planet can see, and they can see their answers. So I put in one, powers of the clerk to the court, and it's still up there now, you can read it. And what they've done is they got back and they've told me where I can find the powers of the clerk of the court. They're scattered about in different acts, the Court Acts, County Court Acts, etc., etc. But if you go to that particular thing, powers of the clerk of the court, you get everything you need to know.
I mean, I knew in a magistrate's court, it is literally all down to the clerk because he advises the magistrates on
Well, the
what
magistrates only
laws
get
and
3
stuff
days of
like that
training.
because
They're
they
not
know
legally
nothing.
trained. They're not
Yeah.
legally trained.
And the clerk advises them.
Right.
But I was really shocked last week when the clerk said we want to get her back in front of Judge Pert because I thought, well, it's not his business, it's this QC dodge. I can't remember if it was a QC or a judge. I think it was a QC.
It's part of
wasn't
their
it?
job that they arrange times and dates and shit like that.
How do you stand if someone psychologically assessed you wrong as well and contradicted a previous report or something
Or
like that?
15 years long.
Yeah,
Well,
yeah.
you need to have an independent assessment made.
Yeah.
The reason that Anne Gregg got out, Anne Gregg left the house one day to
That's
go
what
and
else
empty
we're
the
doing with
dustbins.
Melanie Shaw.
Yeah. Left the house to go and empty the dustbins. And she got jumped by 2 cops and 2 fucking medical guys, social workers. She's thrown to the ground, had her pants pulled down, and a needle jabbed in her bum.
Bloody hell.
She woke up in a psychiatric hospital,
Section.
yeah, on a section, and the psychiatrist said to her, if you don't take this medication, you're not going to get out. It's standard practice, it's a psychiatric girl like. But she had the presence of mind to arrange for an independent assessment. So after a few days, she got released.
How could you do that if she was held sort of incommunicado?
I'm not sure exactly how it went,
Yeah.
but that's how she got released. Independent assessment.
This is why it's important. You mentioned power of attorney.
Power of
last
attorney,
night.
going back to
That
what I
would
was
be
saying
useful,
last
so-
night. Power of it.
It sounds similar what happened to Griffin Colette.
You have to understand that when you're going into a war here, and there's certain theatres of war that you're going to be in, and you're going to be attacked from different directions. Listen, we arrested Michael Peake, a judge, in his own court 3 years ago in Birkenhead.
Yeah.
We've chased out district judges, we've chased out magistrates, we've chased out clerks. We've had clerks of the court standing there in tears. We've had to go and comfort them. We've hardly had any shit from the state. When we arrested Michael Peake, cops came in and kettled the guys in the court, and the people came in and kettled the cops. They shut down the whole city centre.
Yeah. We all had his little black umbrellas.
Were you there?
Yeah.
Well, you know what happened then?
Yeah.
What did they say? They said, oh, can you let us take the dog away,
The
please?
first one I ever sort of
Yeah.
went up
Was that the one where everyone started chanting, do your job?
Do your job.
Yeah.
Do your job.
Right. So that was a big thing that we did then. But we get very little shit for it. But the moment you say this guy's a paedophile, you've got
Yeah.
everybody. You've got MI5, you've got the cops, you've got the council, you've got the VAT man, you've got the tax man, you've got fucking PDSA coming at you. So if you're going to be involved in a paedophile thing, you need to learn how to fight in the law.
Yeah.
You need to learn how to defend yourself and how to attack. This is about attacking.
This is what Robert Greene needed to know, really, wasn't it? Because
Well,
now he's gagged for
yeah.
life.
I worked with Robert quite a lot, and there was something very strange going on there.
Very.
I sat round the dinner table with him, and I said to him, you need to do this in common law. And he said, I don't want to start experimenting at this stage of the game. And I said, you're up on breach of the peace, it's a common law offence, it's not an experiment. You can't go in there with equity and free man stuff, it won't work.
Well, as far as I'm concerned, it might sound a bit like house looking, but if you advised me to do something, I would be doing it, wouldn't you, Will?
I think so.
Yeah.
Or at least after I've done my due
Yeah.
diligence.
Mickey was saying about somebody was, I think Tom Crawford was talking about civil arrest.
Yeah.
If you lay a hand on anybody, it's assault. You do not have to. A policeman can stand out in the street, look up at you at the 3rd floor, and tell you that he's arresting you for breach of the peace inside your own front room. He doesn't have to touch you.
If he did touch you, that would be assault.
Assault, yeah.
Assault,
So
isn't it?
if he did that
We keep
and
saying
you had the implied right of removal, how would he come and seize you?
You can't come in if you've got remote
Exactly.
right of in.
Well, if he's got a
Yeah.
claim against you, he can come in.
If he's making an arrest, yeah.
Yeah, he's
Okay.
got. He
So
can kick
kicks
your door in.
Yeah.
blah blah blah.
Yeah. And
Right,
then if it
just-
falls through, that's when you take it up
And then it
afterwards.
becomes a private. Yeah.
Yeah, just briefly here. About 4 years back, up on FMOTL, I put up a little post called "Other Ways to Take Your Kids." Right? It's not just about getting a birth certificate to social services. Up under certain conditions, put them straight into care. Come to your house. You can break your door down under certain conditions to get the kid. It's not just about social services turning up with a fucking birth certificate and taking the kid. There's a lot more to it than that. Now I've got a sister-in-law who's a social services, and I talked with her several years ago, and she finally admitted that without the birth certificate they cannot take the kid. And then she said to me, but we do have other ways. And I said, what are they? And she said, I'm not telling you. And she still won't tell me.
Everyone's left on that.
Have we got any questions on the Lien stuff?
A commercial lien is a tort, is it? Is that
Right, do you know what a
question?
tort is?
I'm not going to be able to pull
I think I need to be reminded.
A tort is any wrong done to you outside of a contract.
Okay. So it's almost like breaching your own peace.
You're going to get all this on your memory stick anyway, aren't you?
Yeah.
Yeah, there's a whole bunch of stuff there.
Mickey's got it all on here, so we can
Yeah.
Yeah.
transfer it over, can't we?
Up there, the CPR, that's the civil procedures rules that you can go through when you want to start your claim. Don't be daunted by it. All you've got to do is this was part 7. Apparently they've done away with that now, and all claims are now here in part 8. But this was how to start a claim. So you open that one up, and it tells you exactly what you need to do to start your claim. You can't go wrong. If you stick with that, you can't go wrong. Don't get creative. And over here, part 6, that tells you who you got to serve your documents on and how to do it. So you cannot possibly go wrong. If you go and hire a lawyer, this is what the lawyer will do. The lawyer will open that up, and he'll follow this to run your claim for you. So-
Charge you about £80 an hour for
Right,
Just
now,
to check a list.
yeah, if you find yourself being arrested or charged with something and it doesn't work out, so you've got counterclaim. The proof of your counterclaim as well is claim failed. But you can start a counterclaim at any time anyway. And if you go to part 20 here, counterclaims, tells you how to run about the counterclaim. So whether you're starting a claim or you're doing a counterclaim, this is not a problem. Now, if you once you've got your commercial lien sorted, and you've got it up in court, and you've got the order, once you want to start using the court to enforce the debt, whether it's imprisonment or bankruptcy or charging orders, this is where you come. If you come here to part 70, this is about general rules about enforcement. This is exactly what they use against us. Exactly the same. Now you come here, third party debt orders, charging orders. That's the That's the powerful one. This tells you how to go about getting your charging orders to, you know, stop them selling the house, to put everything in your name. It seems like a lot, don't be intimidated by it. There was a time when I used to open up a car bonnet and an engine and look and go, fucking hell, and just walk away. I rang my mate up one time, I said, my car won't start. He said, what have you done? I said, well, I've tried everything I know. He said, okay, I'll be right round. So he got right round and he said, okay, what did you do? I said, I told you I've tried everything I know. He said, yeah, what did you do? I said, I put the key in, fucking turned it. That was it. I lifted the bonnet and went, oh crap. And it took me a while to realise that you've got the engine block, you've got a water system, electric system, oil system. And if you isolate something, it becomes sensible then. And this is what you do with this. The only thing you're interested in here is start a claim, rules of service, who the documents got to go to, and then if you get the order of the court, then jump up to part 70, 72, 73, ignore the rest of it. Because what you got here is a water pump problem. There's no point in looking at the oil in the fan belt and stuff.
Yeah.
I trained as a service engineer at college, and they told us that technique is what I would describe as half split.
Yeah.
You break it down into a block diagram,
Yeah.
and then you look at the block you're interested in.
Well, the engine won't start. It's not going to be a water or oil problem,
Exactly.
is it? It's electrical, something to do with that, so you focus in. Same with this. Now, part of this is practice directions. You get the rules themselves, you get practice directions.